Well, thank you, Mr. Chairman, and I'm actually somewhat astonished to see in the United States Senate something resembling actual debate breaking out.
It won't last.
And discussions of great principles of constitutional law. You know, I will note on this topic that when originalism comes up, critics of originalism often misunderstand it or mischaracterize it and use the phrase original intent, which is not, in fact, what originalism is all about. That the subjective intent of the framers of the Constitution, the subjective intent of the Congress that proposed the 14th Amendment, is not ultimately what is controlling. Rather, it is the text of the Constitution and the original public meaning, what the American people would have understood. The text of the 14th Amendment, one of the most foundational and transformational amendments passed in the wake of the Civil War, provided that no state shall deny any person the equal protection of the laws. And right in there was a requirement for equal protection. The Supreme Court in 1896 in Plessy versus Ferguson unfortunately disregarded the plain command of the Equal Protection Clause and created instead the doctrine of separate but equal to justify segregated schools, to say that even though state government laws that said African American children cannot attend school alongside white children, even though they were plainly being denied equal protection of those laws, the Supreme Court was going to justify that by declaring it to be separate but equal. Plessy was an act of judicial activism. Brown overruled Plessy. And I would note that Justice John Marshall Harlan, who was the lone dissenter in Plessy and who's often referred to as the great dissenter, Justice Harlan's dissent wrote correctly that, quote, "The Constitution is colorblind and neither knows nor tolerates classes among citizens." That was the view that I believe was faithful to the text of the Equal Protection Clause, and it was the activism of Plessy that was rightly and unanimously overturned in Brown.
If we can keep this going a bit, and now you'll have all your time, just from curiosity's sake, the record that was formed in the lower court litigation that in fact separate was not equal. Was that appropriate for the court to consider the facts on the ground, that the defense by each state was, no, we comply because separate is equal, and the court found from litigation that it was not? So that's not inconsistent with originalism, right?
Well, sure, and in litigating Brown, they built a factual record to demonstrate that it was not remotely equal. Thurgood Marshall was integral in that litigation effort. It's one of the reasons why he is remembered by history as one of the greatest Supreme Court advocates to have ever lived, for building that factual predicate and achieving that.
And it was okay to look at the record as part of the inquiry.
In every case, the record and the actual facts are central to resolution.
Thank you, Senator Cruz. Now you can ask questions of him.
So, welcome to the discussion club.
Thank you, Senator.
Let me ask you just a general question. If you are confirmed and find yourself serving as a judge on the Court of Appeals, how would you describe your jurisprudential approach?
I couldn't understand the last two words that you said.
How would you describe your jurisprudential approach?
Senator, I would apply the law. I would apply Supreme Court precedent to the extent that it's controlling. It's totally binding on the circuit courts. I would apply the law. I would then, to the extent it was a matter of statutory or constitutional interpretation, I would, as I said, apply the ordinary meaning, the ordinary public meaning of the text at the time the text was written. I would not impose my will as a judge. I would not make law.
And how would you define judicial activism?
I would define judicial activism as judges that impose their policy preferences in their decisions, or driven by an outcome in a decision based upon a particular policy preference, imposing their will on the outcome or on the matter that they're considering.
Tell this committee your views on the importance of the Constitution's protections of our rights to free speech.
Senator, I am a strong supporter of the Bill of Rights, including the First Amendment, and my experience in my career demonstrate that. As both a prosecutor and as a defense attorney, I'm committed to supporting the Second Amendment. I also support the Fifth Amendment. I support the Sixth Amendment. I support and enforce the Fourth Amendment. I support the 10th Amendment. They're all important, Senator. The First Amendment, freedom of speech, freedom of religion, are really the bedrock foundations upon which our country was founded.
And why does free speech matter to the American people? Why should someone at home watching this hearing care about judges who will protect our rights to free speech?
Senator, the worst forms of government, when we look back in our history, the right to free speech was denied. The right to free speech is fundamental to the foundation of our country, to the liberty protected by the Constitution. It's central to our form of government.
So same question, but this time concerning religious liberty. Why does it matter to the American people that we have judges who will protect our rights of religious liberty?
Senator, it's extraordinarily important that judges protect all of our rights contained in the Bill of Rights, including the First Amendment religious liberty clause, for the same reasons I mentioned with the free speech clause. It's a bedrock it's a founding principle of our Constitution.
Thank you very much. And Mr. Chairman, Mr. Chairman's gone, but I will note for the record a rather astonishing thing, which is we had a debate about originalism, and somehow Senator Lee did not interject. And I've always believed in miracles, but we've now witnessed one in this hearing room.
And yet, my time having expired at the moment, and the chairman still being in the room, I couldn't interject. It was difficult.